Welcome to the deep dive. Today we are cracking open one of the most critical pieces of legislation affecting, well, pretty much everyone with a phone or internet connection.
That's right. We're talking about the Regulation of Interception of Communications and Provision of Communication-Related Information Act 70 of 2002.
Or, as everyone just calls it, RICA.
Exactly, RICA. It's really the bedrock law for how digital communication gets treated by the state, by law enforcement. It lays down the rules for when they can listen in, what info your service provider has to keep about you, and crucially, for how long.
It really is that constant tension point, isn't it, between personal privacy and state security needs.
Absolutely. And for you, the learner listening in, maybe you're just curious about why you had to give so many details to get your SIM card activated, or perhaps you're prepping for a legal discussion on surveillance law.
Our mission today is clarity. We want to navigate its purpose, its, let's say, sometimes complex rules, and what it actually means day to day.
And context is key here. The act itself was assented to way back, December 30, 2002, but its rollout was, well, it was slow, complicated.
But some major parts didn't even kick in for years afterwards.
Precisely. Like the SIM registration rules, those came much later. So you've got this framework technically over 20 years old now, trying to manage today's hyper-connected world. And it's still evolving. We saw updates reviewed and changed as recently as October 2024.
Okay, let's unpack this. Let's start right at the beginning. Why? Why did the government bring RICA into existence? What was the driving purpose?
Well, the core idea stated in the act itself is that the state needs defined legal ways to investigate serious crime and threats to national security. But critically, those methods have to be strictly regulated to prevent abuse.
So it's a balancing act from the start.
It is. RICA basically does four key things. One, it regulates the actual act of intercepting communications. Two, it regulates how communication-related information, that's your metadata, is provided. Three, it sets up this very strict judge-controlled system for warrants, which the act calls directions, to authorize these actions.
Right.
And fourth, it actually mandates that service providers like your mobile network or ISP must build and maintain the technology to allow for interception and data storage when lawfully required.
Right. That fourth point sounds like a big one for the providers. But before we get there, let's nail down some key terms. If this is the rule book for state listening, we need absolute clarity on what they mean by intercept.
Okay, intercept is all about the content, the actual substance of the communication.
So hearing the phone call, reading the email?
Exactly, or viewing the video message. The act says it's the oral or other acquisition of the contents using some kind of interception device. It includes monitoring, viewing, inspecting, anything that makes the content available to someone who isn't the sender or the intended recipient.
And what counts as a communication under RICA? Is it just phone calls?
No, it's much broader. The act splits it into direct and indirect. Direct is simple, face-to-face talking. Oral communication in immediate presence.
Like this conversation right now, if we weren't recording it.
Precisely. Then there's indirect communication. And that's basically, well, almost everything else. Speech, data, text, images, signals, anything transferred via a postal service, or, more importantly for us today, a telecommunication system.
So emails, texts, browsing data, social media messages.
All indirect communication. If it travels over wires or airwaves, it's covered.
Okay. And then there's the other big category of information, maybe even more commonly sought after, communication-related information. This isn't the content, right? This is the metadata.
Exactly. This is the data about the communication. And it's often held in the records of the service providers. Think switching info, who called who, the destination number, how long the call lasted, what device was used.
And location data, too.
And where clickable, yes, the user's location within the network at the time. This stuff is gold for investigators because it maps relationships, movements, patterns, who talked to whom, when, where, how long, even if you never know what they actually said. So, with those definitions in mind, RICA starts Chapter 2 with a really strong statement. Section 2 lays down the general rule. No person, absolutely no person may intentionally intercept or even attempt to intercept any communication within the Republic. Full stop. It's illegal.
Unless
You fall into one of the specific, tightly defined exceptions.
Here's where it gets really interesting, because these exceptions are the legal gateways. They're how surveillance actually happens under the law. What's the main one?
The most obvious one is interception under a valid interception direction, Section 3. That's the formal warrant we mentioned, issued by a designated judge. If law enforcement has gone through that process, the interception is lawful.
Okay, the formal route. But what about everyday situations? Say I want to record a business call I'm on just to make sure I get the details right. I don't need a judge for that, surely.
Correct. That falls under the party to the communication exception in Section 4. If you are actually participating in the communication, you can intercept it.
So I can record my own calls.
You can, but there's a catch for private citizens. You can't do it for the purpose of committing an offense, and the rule is stricter for law enforcement. An officer, even if they are part of the conversation, can only intercept it if they have reasonable grounds to believe it's necessary for reasons similar to needing a full direction, think serious crime investigation.
So an officer can't just record every conversation they're part of on a whim.
No, the standard is higher for them under this exception. The badge doesn't grant automatic recording rights for their side of things unless those serious grounds exist.
What about getting someone else's permission? If I'm talking to someone and they say, yeah, go ahead, record this.
That's covered by consent in Section 5. Interception is allowed if at least one party to the communication gives prior written consent.
Written consent. That's key.
It is. Verbal consent isn't enough under this section. And again, like the party to the communication rule, this exception doesn't apply if the interception is done to help commit a crime.
Okay, shifting gears slightly. What about the workplace? Many companies monitor employee emails or internet usage. How does RICA handle that?
That's the business monitoring exception, Section 6. It allows a person carrying on a business to intercept indirect communications, so emails, network traffic, that sort of thing, if it relates to their business.
Like monitoring transactions or checking if the system's being used properly?
Exactly. Or detecting unauthorized use, like preventing data leaks. But, and this is crucial, there are two conditions. First, the system controller, usually the employer or IT department, must consent. Second, the users, the employees, must be informed in advance that this monitoring might happen.
Informed how? Like in the employment contract?
It could be explicit, yes, like in a contract or IT policy they sign. Or it could be implied by the circumstances, though explicit is safer legally. The point is, the employee needs to know monitoring is a possibility. If they haven't been told, the monitoring isn't lawful under this section.
Right. Makes sense. Now, what about real emergencies? Life or death situations where there's no time to get a judge involved.
RICA has two very specific, very urgent exceptions for that, which bypass the need for prior judicial sign-off. First is preventing serious bodily harm, Section 7.
Okay.
A law enforcement officer can intercept without a direction if the situation is so urgent they can't possibly apply for one. And the sole purpose is to prevent serious bodily harm or someone taking their own life, and they genuinely believe someone involved in the communication is making that threat.
But there must be oversight afterwards.
Immediately afterwards, they must submit a detailed report and an affidavit explaining everything to a designated judge as soon as possible after the interception starts. Accountability is built in, even in emergencies.
And the second emergency exception?
That's the emergency location exception in Section 8. This is purely about finding someone's location quickly. It allows interception only to determine the location of the sender if there are reasonable grounds to believe there's an emergency. Someone's life is in danger, they're dying, or seriously injured.
So pinging a phone in an emergency.
Essentially, yes. And just like the Section 7 power, it requires immediate action, but also immediate reporting back to a designated judge afterwards. The judge has to keep records of these emergency location requests for at least 5 years, too. So it's a powerful tool, but with strict post-event scrutiny. Now let's talk more about that formal process, the directions or warrants. This whole system, detailed in Chapter 3, really hinges on judges acting as gatekeepers.
Right, you mentioned applications have to come from high-ranking officials.
Yes, the applicant has to be a senior person from the police service, the defense force, the intelligence agency, or the NPA's investigating directorate. And the person who issues the most serious directions is a designated judge, usually a retired high court judge, appointed specifically for this role, ensuring some independence from the executive branch.
Okay, let's break down the main types of these directions.
Yeah.
You suggested thinking of them as levels of access, which sounds helpful. Level 1 being the most intrusive.
Exactly. Level 1 is the interception direction under Section 16. This is the big one. It authorizes getting the actual contents of communications, reading the messages, listening to the calls.
And the bar for getting this must be high.
Incredibly high. The applicant needs reasonable grounds to believe that a serious offense is being has been or will be committed, or that there's a threat to national security or public health. And typically, they also have to show that other investigation methods have failed or would be too dangerous or just wouldn't work.
What counts as a serious offense?
Yeah. RUCA has a list, Schedule 1. It includes things like high treason, terrorism, organized crime, drug trafficking, murder, anything potentially getting life imprisonment or more than 5 years. And significantly, it's been updated to include certain serious cybercrimes too, especially those involving big financial losses.
And how long does one of these top-level directions last?
Maximum of 3 months at a time. They can be renewed, but each renewal requires a fresh application showing it's still necessary.
Okay, so that's level 1, content. What's level 2?
Level 2 is the real-time communication-related direction, Section 17. This gives investigators ongoing metadata as it's generated.
So not the content, but things like location tracking in real time. Who someone is calling right now.
Precisely. Who, when, where, duration, but live as it happens. The grounds are similar to Level 1 serious offense or an offense in Schedule 2, a slightly broader list, or national security threat. Still needs a designated judge. And again, max 3 months duration per direction.
In level 3, you said this one's easier to get.
Relatively speaking, yes. This is the archived communication-related direction, Section 19. This is for getting stored metadata, historical records.
Like last month's call logs or location data from yesterday.
Exactly. Because the data already exists and isn't being intercepted live, the potential privacy intrusion is seen as slightly lower. So while a designated judge can issue these, they can also be issued by any high court judge or even a regional court magistrate or a magistrate.
So a broader range of judicial officers can authorize access to historical metadata.
Correct. It reflects that difference between live interception of content or metadata versus accessing stored records.
Okay, that clarifies the judicial side. Now let's shift focus to the companies caught in the middle of all this, the service providers. You mentioned earlier they have huge obligations under Chapters 5 and 7.
Huge is probably an understatement. Section 30 lays out some core mandates specifically for telecommunication service providers. First, they must provide a service that is technically capable of being intercepted. They have to build that capability in.
They have to build the tools for the state to listen in, essentially.
Yes. And second, they must store communication-related information, that metadata we talked about.
Right, how long do they need to keep it?
The Act says the specific period is determined by a directive, but it must be not less than 3 years and not more than 5 years from the date of the communication.
3 to 5 years of metadata for all their customers. That's a staggering amount of data.
It is. Think about the storage infrastructure required. And here's the kicker. Section 35 makes it crystal clear who pays for all this.
Let me guess. Not the government.
Not directly, no. The service provider bears the full cost. The investment, the technology, the maintenance, the operating costs for enabling both the interception capability and the massive data storage.
Wow. So it's essentially a cost of doing business mandated by law.
You could call it a kind of privatized surveillance infrastructure cost, yes. And the state takes compliance very seriously.
How seriously? What are the penalties if a provider doesn't comply?
They are severe. Section 51 outlines them. If a company, a juristic person, fails to comply, the fine can be up to R$5 million. If an individual employee or director is responsible, they could face a fine up to R$2 million or even 10 years in prison.
Okay, so the message is build it, maintain it, pay for it, or face massive consequences.
That's the essence of it. There's very little wiggle room on these core obligations.
And beyond just storing the communication data, there are also strict rules about knowing who your customers are, especially for mobile services. This brings us back to that SIM card registration process.
Yes, that's primarily Section 40, which really came into force around July 2009. It states that an electronic communication service provider, think your mobile network, cannot activate a SIM card for a customer unless they record and store certain details.
Like name and ID number.
Full names, ID number or equivalent for non-citizens, and at least one physical address, residential or business.
And they have to check this information, right? It's not just taking your word for it.
Correct. Verification is mandatory. They have to see a valid identification document. And for the address, they need to see proof, like a utility bill, a bank statement, a lease agreement, something official, and usually not older than 3 months, to confirm your physical address.
So they tie your digital identity, the SIM card, to your verified physical identity.
Precisely. But Section 40 goes even further, particularly subsection 9. It mandates recording and storing the link between every MSISDN.
That's the phone number associated with the SIM card.
Right, and every IMEI number that SIM card is used with.
Ah, the IMEI. That's the unique serial number of the actual phone handset itself, isn't it? Like its fingerprint.
Exactly. So the provider has to log. This phone number was used in this specific physical device and vice versa. This specific physical device used this phone number. That link is incredibly powerful for tracking.
And how long must they keep that registration and IMSISDN pairing data?
For 5 years after the customer stops using the service or the SIM card is deactivated, so the data lingers long after you've potentially moved on. If we connect this to the bigger picture, what RICA really represents is this complex, sometimes uneasy balancing act. On one side, it tries to create strong judicial checks and balances, especially for intercepting the content of communications. You need that designated judge, those high thresholds for serious crimes.
The oversight part.
Right. But on the other side, it imposes these really extensive, very costly obligations on private companies to build the surveillance capability and, maybe more importantly, to collect, verify, and store vast amounts of metadata and identity information about all of us. It's the system of, you could say, institutionalized, privatized information capture, all set up for potential state access.
So what does this all mean? When you boil it down, what's the practical upshot for people interacting with this system every day?
Well, I think one of the most striking implications comes from combining that mandatory MSISDNEI registration, linking your verified face to the physical phone in your hand, with the speed at which that information must be handed over when required.
You mean how quickly the providers have to respond to a direction?
Exactly. That specific information, the record linking the phone number to the device's serial number tied to your verified ID, Section 49, says the service provider must provide that to an applicant within 12 hours of receiving a direction for it.
12 hours? That's incredibly fast.
It is, and that 12-hour clock really underscores the near instantaneous nature of modern state data demands. It reflects the operational reality that for law enforcement to effectively track suspects or respond to emergencies in a digital age, they need that identifying link between a person and their device almost immediately. That mandated speed, built on top of mandated data collection and storage, fundamentally shapes the dynamic between citizen privacy and state power in the 21st century, all stemming from a law drafted back in 2002. It's quite something to consider.